The Biden censorship case hits the Supreme Court. We've been following this one since the district level, when the Biden administration got the old backhand from the lower level court saying you are censoring Americans' free speech in violation of the First Amendment, and you have to stop that. Now, we've been playing this game, this back and forth with the courts, where one court will enter an order stopping the Biden administration from censoring all of us, from using CISA, from using the FBI, Department of Homeland Security, to go put pressure on the big tech companies to keep us all in line when we start stepping out. But then the Court of Appeals would lift that order. So Biden would be stopped, then they would be allowed, then they would be stopped again, then they would be allowed, and so on, around and around this game would go. Well, now we're at the highest court. We're at the Supreme Court, but the Biden administration is not stopped from continuing their censorship until we get some further action from SCOTUS. And so this is the big one. Remember, the court is 6-3, so-called conservatives to the left. And so we're wondering, what are the Supremes going to say about free speech and about censorship? How far can our government really go? But the good news is we're there, so we're going to get some final clarity on this at some point soon. Supreme Court temporarily blocks the order in the Missouri social media lawsuit, which is a little bit of a downside. Now, they say they temporarily block the lower court's order that limits Biden's discussions with social media companies. And the backstory, remember, the real big example of this was the Hunter Biden laptop leak. We all knew it was real. We knew it was real. The CIA said it was not real, but it was clearly real. Well before the election, we were talking about it with Tony Bobulinski and others. The emails corroborated Joe's public schedules and so on. But the FBI was telling Facebook and Twitter and others this was a fake hack and leak operation and they needed to suppress it. We knew that was nonsense, but they did it. They also had CISA that was sending requests, and the White House sending requests to literally delete people's free speech off social platforms. They didn't like their posts that were lawful under the First Amendment. So there was a lawsuit filed by Missouri and Louisiana. Their attorney generals, Eric Schmidt, Jeff Landry, been fighting this case for a long time, and they won actually at the lower level. But the Fifth Circuit Court of Appeals in New Orleans last month prohibited the White House, and so they held this limit in effect, saying you can't do this censorship anymore. It stopped them from having practically any contact with social media. Like, huge win. It found that the Biden administration most likely overstepped the First Amendment and urging major social media platforms to remove misleading or false content. But on Friday, SCOTUS, when this case landed there, they placed a temporary stay on the order until it decides the case, which kind of stinks, because when is that going to be? It also agreed to immediately take up the government's appeal, meaning it's going to hear arguments, and issue a ruling on the merits in its current term, which means it runs until the end of June. See how that works? Guess what? That means the government's going to be able to censor all of us until June. We've got an election next year. Hello? Justice Alito, Clarence Thomas, and Neil Gorsuch all dissented, meaning no. They want the limit to go into effect now, right? They want the censorship to stop now. But here's what the opinion says. Now, this is the official dissent. So the court accepted the petition. And here's what it says. This is Judge Alito dissenting. He says, in the case of Missouri and the Surgeon General, Missouri versus Surgeon General and the rest of the Biden administration, says the application for a stay coming from the U.S. government, they want their limit removed, and referred to the court is granted. Okay, so the government wins. Biden people win. The preliminary injunction issued on July 4th, which was a great day, and we read that from the lower district court of Louisiana. We read the full opinion here. It was awesome if you missed that. And it was granted. It was modified by the Court of Appeals at the Fifth Circuit. They say the application for a stay that Biden people filed is treated as a writ for a petition of certiorari, which is the mechanism by which you get into the Supreme Court. And they say the stay that limits them shall terminate upon the sending down of the judgment of this court. All right, so the majority of the court accepted the case and agreed to allow Biden to continue to censor us until we get an answer. Now, these conservative judges objected, right? They said, hey, this is not how we ruled on this, right? We did not say that's okay. In fact, this is our opinion. We are dissenting from the grant of the application for a stay, meaning they don't want the government to have their permission back to go censor people. So it's Alito, it's Thomas, and Gorsuch, all great judges. But my question is, where is Amy Coney Barrett, and where is John Roberts, the Chief Justice? This case concerns what two lower courts found to be, quote, a coordinated campaign, these are the three judges writing, by high-level federal officials to suppress expression of disfavored views on important public issues. And to prevent the continuation of this campaign, these officials, this conspiracy, they were enjoined from continuing to do that. However, it's got to be Coney Barrett and John Roberts. They say a majority of them, 3 plus the 2, without undertaking a full review of the record and without without any explanation, suspends the effect of that limit until the court completes a full review of the case, an event that may not occur until late in the spring of next year. Government censorship of private speech is antithetical to our democratic form of government, and therefore, today's decision is highly disturbing indeed. Now, this case began when two states, called Missouri and Louisiana, and various private parties filed lawsuits against social media companies that had blocked their use of the platform or downgraded their post because they were talking about things that were not important to them, things that were true, talking about lockdowns and lab leaks and talking about election fraud and talking about Hunter laptop story. All of these were like the major issues in 2020, and we couldn't talk about them. So according to these plaintiffs, federal government officials were pulling the strings, coercing and threatening other platforms to censor them. And based on the findings of the lower level court, the district court wrote in 82 pages that the plaintiffs were likely to be able to prove their claims that there was irreparable harm because you lose the time during that window. The government can censor their political opponents between now and June. That's a lot. You can't get that back. There's no way to undo that harm. On appeal, the Court of Appeals agreed. The district court, and they said there was a coordinated campaign, and it was unprecedented magnitude that was orchestrated by federal officials that aspected and jeopardized the fundamental parts of American life. They said that the district court was correct in its assessment that there was unrelenting pressure from certain officials that suppressed millions of protected free speech postings by American citizens. It is so outrageous. And we've made the analogy here. It's like, you see all the yard signs everywhere, the signs on the corner during a political season, how much time and effort and money goes into all of those. You can't just go and remove those. You can't just go pull your opponent's campaign signs off the street corners or knock their billboards down. But that's what they were doing here. And the federal government was literally doing that. Every post, every argument, videos. We got demonetized for 9 months here on this channel. And we had multiple strikes for COVID misinfo, election misinfo, and so on. So to stop this quote campaign, the injunction, as it now stands, prohibits the covered officials from doing two things. They may not coerce social media companies to do content moderation, and they may not meaningfully control the content moderation efforts. But the Biden government was displeased with this, and so they filed an emergency application asking us, the SCOTUS, to stay this injunction. They say under a straightforward application of the normal rules, their application should be denied. They say that we have to consider things like a likelihood of irreparable harm if we don't grant their wishes. But granting this is an extraordinarily high bar. But instead of offering any concrete proof of imminent harm, okay, like what happens if you just stop the government from impeding on the social media companies? What's the harm? Are we all going to die? Are we all going to melt down? If they can't censor us from talking about Hunter, is America going to come to a screeching halt? What is the imminent harm if they can't have this? So the government offers a series of hypotheticals it thinks it might want to take in the future and what it thinks might be chilled. But hypotheticals are just that, okay? May. A lot of mays. But that is not concrete proof. And this speculation here does not establish irreparable harm. The government can come up with all these theories about why they will have harm if they can't censor us, but it's all hypotheticals. It does not appear, says Alito, that any of the government hypothetical communications would actually be prohibited, nor is any such example provided by this court's unreasoned order, saying the injunction applies only when the government crosses the line and violates free speech. Like it only applies to things that they shouldn't be doing anyways. Does the government think that the First Amendment, this is their question, does the government think that the executive branch is allowed to engage in this conduct? Do they think this is legitimate? Does it have plans for this to occur between now and the time this case is decided? Because that's many months of the government taking down the opponent's yard signs. Despite the government's conspicuous failure to establish a threat of irreparable harm, other than, Trump, Trump might win. Wow. The majority stays the injunction and thus allows them to continue to commit their First Amendment violations that the lower courts identified, both of them. The majority takes this action when facing detailed findings of fact. You've seen it all in the lower cases. So applying our already settled test for this and granting a stay, Alito says, I would deny the government's application, but I would specify in the order that in the unlikely event that a concrete occurrence presents a risk of irreparable harm, the government can come ask us for relief at that time. If the government comes to a court and says, we have to censor this post or else Putin's going to win, then they can come and do it and they can file an emergency application and they can get permission to go censor that post. Such an order would fully protect the ability for them to speak out and address this stuff. Now, Alito writes this: at this time in the history of our country, what the court has done, I fear, will be seen by some as giving the government a green light to use heavy-handed tactics to skew the presentation of views on the medium that increasingly dominates the dissemination of news. That is most unfortunate. Absolutely, they are. Are you kidding me? They've got an open window right now. It's between now and June, when the Supreme Court is here, to pull as many yard signs out as possible, to censor as many people as possible, and just say, hey, we had permission to do it. Like literally, we had open season from the Supreme Court of the United States to do it. So I don't know what happened to Amy Coney Barrett. I don't know where she was on this. I don't know what happened to John Roberts on this one, but they weren't with the other conservatives. And so government has full reign for censorship between now until June, unless COTUS does something in the meantime. But my friends, we'll continue to cover this. Thank you for joining us and subscribing, and we'll look forward to seeing you on the next one.